Namaste, welcome to Courtroom. So if you're preparing for judiciary examinations, especially the DJS, and their mains format is quite focused on very recent judgments, this is a good one to track. And this one is on section 397 of the IPC delivered in October. I'll just give you the citation. It's criminal appeal number 903 of 2021. It's Ganeshan versus state represented by station house officer. The case law name isn't exactly that important. I'll leave the link to the judgment down below. You can pretty much very easily find it from the internet as well. So this is on section 397 of the IPC, and DJS tends to do this, that they will take the same very facts from this very judgments, they can, that is, and then ask you to decide. So if you have read it already, if you're acquainted with the case facts, if you're acquainted with the ratio, well, good, more marks. So it's story kahan shuru ho rahi hai? So we are dealing with appeals of Ganeshan and Shanmugam. So they were A1 and A3 as labeled. So originally there were 5 accused, but labels got changed as the trial proceeded. One got acquitted as well, and that acquittal is crucial because we'll just link and connect all the dots together. So hota kya hai that in 1996 A1 to A5 they go to execute a robbery in a car with the intention of committing a robbery. They carried an iron rod and a knife. Ganeshan, जिसकी appeal primarily की हम बात कर रहे हैं, he stayed in the car, and the accused A2 to A5 they went out and they attacked a person and they snatched away a bag which had 60,000 rupees and 16 grams of jewelry. Now this is a lot of stuff way back then in 96, and they ran away and they attacked another witness as well. All right. So the investigating officer, the IO filed the charge sheet. The charge was labeled as 395, read with 397, and post investigation, of course, the charge sheet was filed. Now we need to take a look at the provisions, the relevant provisions of the IPC to understand what is happening here. So I'm sure that hopefully you can read this. Let me just zoom it in, because actually the white light from the bare act reflects on the camera a lot any which way. So 391, if you have the IPC bare act open, please do open it. 391 is dacoity when 5 or more persons. So the crucial point is dacoity mein minimum kitne chahiye? 5 log chahiye, right? Conjointly commit or attempt to commit a robbery. So attempt, yahin pe, this is ingrained. Otherwise attempt is given where? Section 511 of the IPC. That's how you keep on revising stuff. Or where the whole number of persons conjointly committing or attempting to commit a robbery, and persons present in aiding such commission or attempt amount to 5 or more. Every person so committing, every person attempting or aiding is said to commit a dacoity. All right. Now when we go to 395, it says punishment dacoity. Whoever commits dacoity shall be punished with imprisonment for life or with the rigorous, that is RI, rigorous imprisonment for a term which may extend to 10 years. All right. 397. Now see. Now when you compare basically 395 and 397, robbery or dacoity with attempt to cause death or grievous hurt. If at the time of committing robbery or dacoity, the offender uses any deadly weapon, alright, or causes grievous hurt to any person or attempts to cause death or grievous hurt to any person. Now note the crucial words in 397, if at the time of committing robbery or dacoity, the offender, alright, the offender, the person, uses any deadly weapon or causes grievous hurt. Remember the crucial fact, Ganeshan stayed back in the car. Alright, so the A2 to A5, they went in, they attacked a person, they snatched the bag away, they attacked the eyewitness as well, but he was staying back in the car. Keep that in mind and we'll take this discussion forward. Alright. So the trial court convicted the accused for offence punishable under section 397 and pronounced a punishment of 7 years. Feeling aggrieved and dissatisfied, the accused went into appeal. The Sessions Court dismissed the appeal. The appeal to High Court was dismissed and the High Court confirmed the conviction. Now we are in the Supreme Court. Among other defenses, the main point of the defense in this case is that the injuries that they inflicted, the Ganeshan is also admitting कि भाई ठीक है मैंने सब काम किया तो है, but injuries जो करी थी from the person whom we snatched the bag from or the eyewitness that we attacked, they were simple in nature and no dangerous weapon was used. All right, and prosecution is alleging 5 accused but prosecution witness was, so in the facts of the case, I've extracted this out, that there were not more than 3. So one witness is saying not more than 3, prosecution is alleging 5. Since the sine qua non of dacoity is 5 people have to be there, they are just trying to cast a doubt in the judge's mind. If 5 are not there, then dacoity is not applicable. So they are saying that there were no 5 people, but the main point is that they didn't use a dangerous weapon as is the mandate of 397, and they didn't commit any grievous hurt, etc. All right. So their main point is then how 397, and plus the charge sheet was filed after 13 years, so this is a lot of time. All right. So accused is entitled to the benefit of doubt because the standard of which in criminal jurisprudence that you have to basically the standard of proof is that it is you have to prove your case beyond a reasonable doubt, right? So, and there was no test identification parade. This was the main defense of Ganeshan. Prosecution countered all of these points and asserted the fact that trial court, sessions court, high court, all convicted. How are they all wrong? Now you are saying there were no 5 people, but there were, right? So they were alleging this. So now we come to 390. Dacoity के अंदर robbery होनी जरूरी है. So in robbery there is either theft or extortion. Homework for you. I won't go into these details, but do revise robbery. All right. So robbery is the sine qua non to dacoity, and you can say that dacoity is an exaggerated version of robbery. You may want to write this down. Robbery plus 5 persons is dacoity, as is pretty much clear from a bare reading of 390 and 391. And 397 may you either the offender uses any deadly weapon or you are causing grievous hurt as defined in the IPC. So 390 से उतरे 391 के अंदर उतरे 391 से नीचे 397 में जा रहे हैं, बट 397 में दी साइन qua non है. एक तो पहली बात 5 लोग तो होंगे ही, राइट, क्योंकि डेकॉइटी वाला जो एलिमेंट है वो यहाँ पे हो रहा है. रॉबरी के अंदर हमें फिर भी शायद नहीं चाहिए होंगे, क्योंकि इन रॉबरी देयर इज आइदर थेफ्ट और एक्सटॉर्शन. कोई 5 लोगों की ऐसे साइन qua non की रिक्वायरमेंट नहीं है. But if at the time of committing robbery or dacoity, the offender uses any deadly weapon or causes grievous, or I am repeating this point again and again because this is what they're going to ask you. So watch out for that. Now 391 and 396, the Supreme Court remarked that under constructive liability, you can basically apply the doctrine of constructive liability and get everyone in the dock, jitne bhi sare accused the. Offender in 397, the word offender was used in 397, means the person who uses such deadly weapon. 397, now the remarks of the Supreme Court, 397 is attracted only against the particular accused who uses the deadly weapon, and the minimum punishment cannot be imposed on others, as the same thing was decided in Phul Kumar versus Delhi Administration 1975 ka case hai. Citation I have given. Alright, if you want to download this PDF with my notes, etc., the link to that is in the downloads as well. So court agreed with the defense that 397 won't be attractive to award a minimum punishment because Ganeshan was staying back in the car, Ganeshan wasn't using a deadly weapon. How exactly is 397 being applied here? The court didn't agree. But then the next question is, then what do? Do you acquit him or do you convict him under other sections? Because it is not the case that I am completely innocent. Well, that is what every accused wants, but that is certainly not the case here. So the court said that apply 391 read with 395 here, and 395 and 397 are markedly different because herein again deadly weapon or grievous hurt, यहाँ पे कुछ नहीं है. Mark these sections for DJS mains. Alright. Now defense के अंदर defense की जो basically the 5% theory, the Supreme Court didn't basically. The defense didn't work out on this point. The Supreme Court observed that the FIR also mentioned 5 people, the charge sheet also mentioned 5 people, and everything was against 5 persons. Another point was Benny's acquittal. So there was a character called Benny, जो शुरू में हमने बात करी थी. 1 person got acquitted out of these 5. So वहाँ पे Supreme Court basically that point के अंदर कि वहाँ पे भी 5 लोगों के हिसाब से काम हुआ था. So Supreme Court has said that prosecution is already successful in establishing case by leading evidence. We need not even go into Benny's acquittal here. So therefore appeals are partly allowed. The 397 conviction has been quashed but you will be convicted under 391 read with 395. अब पॉइंट क्या है, पॉइंट इतनी लंबी राम कहानी का बेसिकली पॉइंट क्या है जी, पॉइंट ये है दैट दिस, ये जो आपकी जो जजमेंट जो आ रही है, basically it's, you have to keep in mind 397 and 395 के बीच का difference. So they will cook up a story in which deadly weapon won't be used, and they will say that the accused was convicted under 397 and now it is in your court, decide. This is the judgment that they're hinting at. All right, hopefully just go through the judgment once. It's a pretty easy judgment. You can breeze through the facts, I believe. All right, wishing you all the best in your judiciary prep. Take care, bye.